in the United States, we have a federal system. Power in the United States is divided between and shared between two levels of government. We have the United States federal government, that is our central government. Then we have 50 states and several territories. Each of them have a structure in place. They have a governor for the most part. They have a governor that runs the states. They all have or territories. They all have their own constitutions. They all have powers that are very explicit, and some of the powers differ between states. So you have a fully functioning and powerful federal government and fully functioning lower levels of government. So in that instance, you have to very clearly define what can be done by the different levels of government. That's the only way that this works. And even with that, even with us having a roadmap in the United States Constitution, there are still conflicts where states are saying, no, that's a state power, you can't do that. Federal government is coming in and saying, you're trying to do something that is a violation of federal law, you can't do that. So let's just talk about the types of power in our federalist system. We're going to start with delegated powers. In this instance, when we're talking about delegated powers, we are talking about powers that are given to the United States government. Now, this is a Texas government class, but we have to get really straight in our minds what are federal powers and what are state powers. So let's look at Article 1, Section 8. Article 1, Section 8. I'm going to say it one more time. I want you to say it with me. Article 1, Section 8 of the United States Constitution. Here it says Congress, and here they mean the United States Congress, has the power to lay and collect taxes, duties, imposts, and excises. And then it goes on to list 16, 17 more powers that the federal government has. They can borrow money. They can regulate commerce between the nations, among the states, and with Indian tribes. And they put that in because Indian tribes were recognized as a completely separate entity from the states where they were located. The federal government has the power to coin money. It has the power to provide for punishment of counterfeiting, to establish post offices and post roads. It is very explicit to provide and maintain a navy, to make rules for the government. All of these are express powers. It's very specific. You can provide for and maintain a navy. You must provide for and maintain a navy. You must regulate commerce. These are very large powers that the federal government has. Then right here at the bottom, it gives the federal government the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Foregoing are those 17 up above. And all other powers vested by this Constitution in the government of the United States. This is sometimes called inherent or implied powers. Sometimes this clause is called the necessary and proper clause. Another word for it is the elastic clause, because it expands and basically says that the United States Congress can pass any law which proves to exercise one of the powers that they are specifically granted. They can They have the sole power to declare war. So they can make a law and say war is now declared on. They can set up court systems to constitute tribunals inferior to the Supreme Court. They set up the court system through laws. And they have really done that. They started with the Judiciary Act of 1789. We have seen a lot of, if you've watched the news, we've seen a lot of blowback about the post office. The Postmaster General, I think his name is DeJoy, has come under fire because he shut down some sorting machines. He cut back hours. He, in general, has worked to slow down postal service, and the Congress, United States Congress, is investigating because the post office is one of their responsibilities. So the powers that are given under the necessary and proper clause are implied powers. The powers that are listed explicitly are called express powers. Let's look at Article 1, Section 10. And again, we're still in the United States Constitution. In Article 1, Section 10, you find a list of things and provisions that states are prohibited from. Notice that each paragraph starts with no state shall. And there are a list of things that states can't do. For instance, states cannot coin their own money. They cannot grant any titles of nobility. They cannot pass a bill of attainder, which is quite simply a law that says that something is illegal without a trial. They cannot pass ex post facto laws. Neither can the federal government. You can't make something illegal and then go back and convict someone of it if it was not illegal at the time that they did it. They are not able to, without the consent of Congress, put any taxes on imports and exports. They're not able to keep troops without the consent of Congress. They're not able to keep ships of war in times of peace without the consent of Congress. They cannot engage in war unless actually invaded. So this is Article 1, Section 10 of the United States Constitution, and it lays out the things that the federal government, the state governments cannot do. We'll look at one more provision. This is Article 4 of the United States Constitution. Article 4. This lays out things that states must do. So Article 1, Section 10 explains what states cannot do. They're prohibited from doing. Article 4 lays out things that states must do. One thing that states must do is give full faith and credit to the laws, records, and judicial proceedings of other states. We call that the full faith and credit clause. If someone gets married in Maine and they move to Texas, you are going to Texas has to recognize that marriage because that is a public act. If someone has a lawsuit and they won a lawsuit in Hawaii and they move to Texas, if they bring that judicial proceeding to a court in Texas, Texas has to help them enforce it. Another thing that states must do is provide privileges and immunities of citizens to citizens of the United States, regardless of what state they are from. So you cannot tell someone you can't buy a house in Texas if you're not a Texas resident. So I always get two questions when we are talking about the Privileges and Immunities Clause. One thing that students ask about is the fact that you have to pay out-of-state tuition if you have not established residency in a particular state. Your tuition is higher. It seems like you're being treated differently because you are not a citizen of the state. Well, I guess I have to introduce you to something that I call a Madelinism. And that is simply this. That means it's not in the Constitution, it's not in a book, it's just in my mind, but that doesn't make it wrong. First, Madelinism is a law is not unconstitutional until the United States Supreme Court says it's unconstitutional. I would posit that it probably is a violation of the Privileges and Immunities Clause to charge out-of-state tuition for a year or two until you establish residency. But nobody has filed that suit, and so the Supreme Court has not had the opportunity to rule on that particular law. So if you had that question, you are absolutely correct. So let's talk about the types of powers in our federal system. We're going to discuss two. We're going to discuss reserved powers. These are actually powers reserved to the states. And we'll discuss concurrent powers. These are powers that both the federal government and state governments have. And in some instances, local governments as well. So let's talk about the way that we settle disputes over federal law and state law. There's got to be some type of order. And what the United States government decided to do was give us what is called the Supremacy Clause. This is found in Article 6 of the United States Constitution. And notice that it says right here, this Constitution, the United States Constitution, the laws of the United States, and all treaties made under the authority of the United States shall be the supreme law of the land. So that's the way we settle disputes. If there is a conflict between state law and federal law is going to trump or be supreme over state laws. It says the judges in every state are going to be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. And so I've already introduced you to the Madelinism. It becomes even more apparent when we really look at state laws that vary from state to state, and federal law, which is often very clear. So let's take, for example, legalized marijuana. Some states allow recreational use of marijuana. I think we're up to 10, 13 states now. Some states allow marijuana only for medicinal purposes. So you have to have you have to have a prescription. Louisiana is one example. I think Arkansas recently as well, not Texas. Texas is among those states that does not have any or very insignificant amount of marijuana use allowed. In Texas, recently the Supreme Court, maybe 2 sessions ago, allowed the use of cannabis for children that have severe epilepsy, and it named the 5 places in the state where dispensaries could be established. As far as I know, there's only one. And it's, again, only in that very isolated incident. You have a young child. There have been bills that have sought to allow medical marijuana. There have been bills that have sought to allow veterans to use cannabis that have a diagnosis of PTSD, and the state of Texas has roundly rejected those. But check this. The federal government has a law that says that the use of marijuana, cannabis, is a Schedule 1 drug, is the use of it for medicinal and recreational purposes is strictly prohibited. So you have this federal law that says there is no circumstance under which it will be legal with the federal government to use marijuana. And then you have 39 states, 40 states that to some degree allow use of marijuana. Now that is a conflict. State laws, states are going to be bound by this Constitution and the laws of the United States. So if the federal government decided, and in many years past they certainly have, that they wanted to go in and shut down dispensaries in Colorado or California, they could do so because those people are violating federal law. Even today, if you own a dispensary, you cannot deposit that money in a federal bank. Most just use cash. You could use a savings and loan or a state bank. But the reason that these states are able to continue to do these activities, which are a clear violation of federal law, brings us back to the Madelinism that I was talking about before. For these to be shut down, for these to be called unconstitutional, the federal government would have to sue. And I promise you that would be a very short suit. Federal prosecutors would come in and say, Your Honor, supremacy clause, drop the mic. But they have not filed suit to date. And who wants to be the president that is has the federal government suing states and removing the right to use cannabis? I would posit that there's nobody. My guess is nobody wants to be that president. So it's just gonna hang precariously until eventually the federal government is probably going to lift that, take away it being a Schedule 1 drug, and eventually states will be just open to make a decision about whether or not they want to allow it to be legal. Finally, let's look at the 10th Amendment. This is a short one, but it is arguably one of the most powerful of the amendments. This is literally all that the 10th Amendment says. That's the whole thing. The powers that are not delegated to the United States by the Constitution, primarily in Article 1, Section 8, nor prohibited by it to the states. We find the prohibitions in Article 1, Section 10. So if it hasn't been assigned to the federal government or prohibited to the states, that power is a state power. It's reserved to the states, respectively, or to the people. So bottom line, if it's not listed somewhere specifically in the United States Constitution, it is technically a state power. States argue this and have gone through several lawsuits where they said federal government is trying to do something that should be a state power.